housekeeping point is just to point out that all of this that we're talking about is not a statute of limitations defense. What it really is, it's an avoidance to the statute of limitations defense. So it's a little different than the defendant coming in and saying, we've got these issues we want to raise. And again, we're not asking the court to resolve those so that there's summary judgment entered from this court. All we're asking is this court to review those legal aspects of this certification order and tell the trial judge where he misapplied the law, and we think he did. And then secondarily, with respect to the issues of reliance, for example, the trial judge didn't determine how such a class action could be managed, since reliance is an individual issue. And we think the trial judge skipped over all of that. And we certainly think at the very least this court could remand and tell the judge to reconsider the certification on that point, not as a merits issue, but as how are you going to try the case where you have 300 people potentially coming in and having to prove the individual issue of reliance, which is an element of the equitable estoppel. So whether you look at these issues as standing for Ms. Conlon, or the class definition and how broad that can be, or how manageable this claim can be or should be.
But counsel, isn't equitable estoppel, doesn't that solely relate to the statute of limitations issue? And I guess I'm troubled, as Judge Padovano said, it's not appropriate to review the summary judgment ruling at this point.
And we're not asking, if the trial judge...
And part of it was the trial judge sort of got into the weeds a little bit, and I'm troubled by that because I don't think we can bootstrap jurisdiction on the statute of limitations issue.
We agree, and so we're not asking you to review the denial of summary judgment, but the trial judge, after denying the summary judgment, then went in and spent pages and pages of the class certification order addressing these issues because he viewed it as a subset of the standing, because he looked at the accrual issue and the avoidances of the statute of limitations as legal issues that he had to address to get at her standing. So we certainly think that is a vehicle how the court could review those legal rulings. So we wouldn't anticipate this court remanding and saying we're entitled to summary judgment, but certainly the court could clarify, for instance, whether or not it's going to apply the Frederick rule, and then remand it and say, in light of our following the Frederick rule, how should the class be certified, if it should be certified? And again, reinforce to the trial judge that when you have equitable estoppel, that it is an individual issue. And so in light of that individual issue, remand it and ask the trial judge to explain how you can certify a class or manage a class if that really is the appropriate legal standard, which we suggest the cases require. So we're not asking for summary judgment on the merits. They like to call it the merits. It has nothing to do with the validity of the impact fees, the validity of the ordinance. He spent a lot of time talking about those issues, and those really are merits issues. We're asking just for these fundamental issues. Is she an appropriate person to bring this? Is this appropriate class definition? Is this class manageable, given the kinds of issues that we anticipate having to litigate here? And so that's why we think the court can look at those legal issues, can reverse and ask the trial judge to reconsider the order in light of what this court reinforces the law to be. Thank you.